Welcome to Bankruptcy Unlocked, your legal path to relief.
Welcome to Is Chapter 7 Bankruptcy Right for You? Understanding who's the ideal candidate. I'm your host, Abigail Vaca, and today I'm joined by the founder of the law offices of Andrew H. Griffin III. Thanks for joining us, Andrew.
Thanks for having me.
Let's jump right in. So, who's an ideal candidate for Chapter 7 bankruptcy? And what financial situation typically leads to someone to consider this option?
An ideal candidate for Chapter 7 bankruptcy is someone who is struggling with overwhelming debt and has limited income or assets. This type of bankruptcy, often referred to as liquidation bankruptcy, is designed for individuals who truly cannot afford to repay their debts and need a fresh start. Typically, someone considering Chapter 7 bankruptcy might be facing financial challenges like mounting credit card debt, medical bills, personal loans, or other unsecured debts that they're unable to manage. If their income is insufficient to cover basic living expenses and debt payments, Chapter 7 can provide relief by discharging most unsecured debts, giving them a clean slate. To qualify for Chapter 7, you must pass a means test, which looks at your income compared to the median income for a household of your size in your state. If your income is below the threshold or you can demonstrate you don't have enough disposable income to repay your debts, you may be eligible. This option is particularly helpful for individuals who don't have significant assets they need to protect. That said, many essential assets like your home, your car, and your personal belongings can often be protected through exemptions. The financial situations that typically lead someone to consider Chapter 7 include job loss, medical emergencies, divorce, or unexpected expenses that have created a debt spiral. When creditors are calling nonstop and it feels impossible to see a way out, Chapter 7 can be a powerful tool to reset and to rebuild. The key is understanding whether Chapter 7 is the right fit for your unique circumstances, and that's where an experienced bankruptcy attorney comes in. We help clients evaluate their financial situation, explore other options, and guide them through the process to achieve the best possible outcome.
Can you explain a bit further what Chapter 7 bankruptcy is and how exactly it differs from other types of bankruptcy, like Chapter 13?
Absolutely. Chapter 7 bankruptcy, often called liquidation bankruptcy, is designed to help individuals or businesses eliminate unsecured debts like credit card balances, medical bills, and personal loans. It's the most common form of bankruptcy for people who have limited income and are struggling with overwhelming debt. Here's how it works. When you file for Chapter 7, a trustee is appointed to oversee your case. The trustee reviews your assets and debts, and if you have any non-exempt assets, those that are not protected by bankruptcy exemptions, they may be sold to repay your creditors. However, most people who file for Chapter 7 are able to keep their essential property, like their home, car, and personal belongings, because exemptions typically cover those items. After the process is complete, most of your remaining unsecured debts are discharged, meaning you no longer legally obligated to pay them. Now, how does Chapter 7 differ from Chapter 13 bankruptcy? The biggest difference is in the approach to managing debt. Chapter 13 is often referred to as reorganization bankruptcy. Instead of discharging debts outright, Chapter 13 allows individuals to create a repayment plan, typically lasting 3 to 5 years. Based on their income and ability to pay, that's how long it lasts, 3 to 5 years. It's a great option for people who have steady income and want to keep significant assets, like a home with an equity or a car they're still paying off. Another key difference is eligibility. To qualify for Chapter 7, you must pass the means test, which evaluates your income compared to the median income in your state. Chapter 13, on the other hand, is available to those who have regular income, who don't qualify for Chapter 7, or who prefer to pay back some of their debts over time. In summary, Chapter 7 is about wiping the slate clean quickly, while Chapter 13 focuses on restructuring and paying back debt over time. Deciding between the two depends on your financial situation and long-term goals. That's where we come in as attorneys, to help you navigate those options and choose the best path that's good for you.
Okay, so let's break it down further. What's the process of filing for Chapter 7 bankruptcy like? And how long does it typically take from start to finish?
The process of filing for Chapter 7 bankruptcy is relatively straightforward, but it's important to understand each step to navigate it successfully. Typically, the process takes about 4 to 6 months from start to finish, though the exact timeline can vary depending on your individual circumstances. Here's an overview of the process. First, we have the initial consultation. That first step is meeting with a bankruptcy attorney. During that consultation, we'll review your financial situation, assess your eligibility for Chapter 7, and discuss whether it's the right solution for you. Secondly, we'll gather the documents. You'll need to collect essential financial documents such as pay stubs, tax returns, a list of assets and debts, bank statements, and information about your expenses. These documents help build a complete picture of your financial situation. Third, credit counseling. Before filing, you must complete a credit counseling course from an approved provider. This is a mandatory step and typically takes an hour or two to complete online or over the phone. Fourth, filing the petition. Your attorney will prepare and file your bankruptcy petition with the court. This document includes detailed information about your finances, debts, and property. Once filed, an automatic stay goes into effect, which means creditors must stop collection efforts immediately. 5, appointment of a trustee. A bankruptcy trustee is assigned to your case. Their role is to review your petition, identify any non-exempt assets, and oversee the process. And 6, you have a meeting of creditors. About 20 to 40 days after filing, you'll attend a meeting of creditors, also called the 341 meeting. During this meeting, the trustee may ask questions about your petition, and creditors can also attend, though they rarely do. And last, debt discharge. If everything goes smoothly, most of your eligible debts will be discharged approximately 60 to 90 days after the meeting of creditors. This means you no longer legally obligated to pay these debts. You don't have to pay them. Your debts are discharged. For most people, the entire process is completed within a few months. Having an experienced attorney by your side can ensure everything is done correctly and efficiently, helping you move through the process with as little stress as possible. Chapter 7 is designed to be a fresh start, and understanding the steps involved can make the journey much more smoothly. One concern many people have about Chapter 7 is losing their property during Chapter 7 filing. How does the bankruptcy court determine which assets can be liquidated?
So you mentioned debt. What debts can or cannot be discharged in a Chapter 7 bankruptcy? Are there any exceptions that people should know of?
The truth is, most people don't lose their property in Chapter 7 bankruptcy. Thanks to the exemptions that protect assets, that many people are not going to lose any of their properties. However, there are some important details about how the bankruptcy court determines which assets can be liquidated. So let me break it down for you. When you file for Chapter 7, the court appoints a bankruptcy trustee. That person will review your financial situation and your assets. The key factor here is that the concept of exemptions. Exemptions are laws that allow you to keep certain property during the bankruptcy process. These exemptions vary from state to state, and they generally cover things like your home, car, personal belongings, and retirement accounts. For example, many states have a homestead exemptions, which protects a certain amount of equity in your primary residence. Similarly, you can often keep your home or often keep your car if the equity is below a certain amount. Even if the trustee sells some of your property to pay creditors, these exemptions allow you to retain the asset, to retain the items that are essential to your daily life and future recovery. Now, if you have non-exempt property, things like real estate, extra valuable collectibles, or high-end jewelry, those could potentially be sold by the trustee to repay the creditors. But the good news is that for most people filing bankruptcy, or most people filing Chapter 7, the value of non-exempt assets is minimal or non-existent. This means that they can keep most, if not all, of their property. Another thing is to keep in mind that in some cases, you could reaffirm certain debts like car loans or mortgages. If you want to keep these specific items and continue making payments, you can keep them. But it's important to know you need to discuss this with your bankruptcy attorney, as it depends on your specific situation. In summary, the bankruptcy court doesn't automatically take everything that you own. The exemptions protect the property you need to live, and rebuild your house or rebuild your life. As your attorneys, we make sure that you're using these exemptions to your full advantage, helping you keep as much of your property as possible, and while still getting the financial relief you need.
Would you have anything further to add about not all debts being dischargeable, like in regards to things like student loans or child support?
Surely. Chapter 7, is dischargeable many types of unsecured debts. However, not all debts can be discharged. So it's essential to understand which ones can and which ones can't. Debts that can typically be discharged in Chapter 7 include credit card debt. This is one of the most common types of debt people file bankruptcy to eliminate. Medical bills. If you've accumulated significant medical expenses, those can often be discharged. Personal loans. Most unsecured personal loans are dischargeable. Unpaid utility bills. They also can be eliminated. Judgment debts. In many cases, judgments resulting from lawsuits like for credit card debts or unpaid loans can be wiped out. Now, that is important to note that the above was previously listed items were dischargeable. There are things that are non-dischargeable. For example, in Chapter 7, there are certain types of debt that remain your responsibility after filing. The first one is student loans. Student loan debt is generally not dischargeable in Chapter 7 unless you can prove that paying them would cause undue hardship, which is a very high standard to meet. But in rare cases, some people are able to have their student loans discharged through a court proceedings, although it's not easy. Second, child support and alimony, spousal support. These family law obligations are not dischargeable. Bankruptcy won't wipe out your responsibility to pay child support or spousal maintenance. Third, taxes. Most income tax debts are not dischargeable, but there are exceptions. If the tax debt is old enough and meets certain criteria, it may be dischargeable. However, navigating tax discharge can be complicated and is best to consult an attorney who can evaluate your situation. Next is debts incurred through fraud. If you incur debt through fraud, such as lying on a credit application, the court may deny the discharge of the particular debt. Debts related to personal injury caused by intoxicated driving. If you caused an accident while driving under the influence and were found liable for personal injury or death, that debt cannot be discharged in bankruptcy. So yes, there are exceptions that you should be aware of. In addition to those categories that I mentioned, there's also something called non-dischargeable debt. If the creditor objects to the discharge, for example, if you committed fraud or engaged in dishonest practices related to a debt, a creditor may object to having that specific debt discharged. In those cases, a court will decide whether or not the debt should be eliminated. It is essential to discuss these details with a bankruptcy attorney to make sure you fully understand which debts can and cannot be discharged in your case. We'll help our clients guide them through these complexities and ensure that they get the maximum benefit from the bankruptcy while understanding that any exceptions that may apply to dischargeability.
So you touched on it before, but how does someone's income level impact their eligibility for Chapter 7 bankruptcy? Can you explain the means test and what that involves?
It's a great question. Income levels played a significant role in determining eligibility for Chapter 7 bankruptcy, and that's where the means test comes into play. The means test is a key factor that helps ensure Chapter 7 is reserved for people who truly cannot afford to repay their debts. The means test essentially looks at your income and compares it to the median income for the household of your size and your state. If your income is below the state's median, you're typically eligible for a Chapter 7. But if your income is above the median, it doesn't actually automatically disqualify you. There's still a second part of the means test that comes into play. Here's how it works in more detail. Step one, we compare your income. The first step in the means test is to calculate your current monthly income, or CMI, which includes wages, salary, Social Security benefits, rental income, and the other regular sources of income you receive. The CMI is then compared to the median income for your household of your size and your state. If your income is below the median, you're generally eligible to file Chapter 7 without further analysis. Step 2, deductions for living expenses. If your income is above the median, then the test looks at your disposable income which is your income after taking certain deductions for living expenses, things like housing costs, utilities, healthcare, and other necessities. If after those deductions, you still have enough disposable income to repay your creditors, you may not qualify for Chapter 7 and could be directed toward filing for Chapter 13 instead, which is a repayment plan bankruptcy. The idea behind the means test is to ensure that people who have enough income to repay at least a portion of their debts don't use Chapter 7 to discharge other debts. On the other hand, it also helps people who are truly struggling to get the fresh start they need. For many people, the means test can seem confusing, but don't worry. This is exactly where an experienced bankruptcy attorney can help. They can really help you. We can calculate your income, apply the necessary deductions, and guide you through the process to make sure you meet the eligibility requirements for Chapter 7, or determine if Chapter 13 might be a better option. So while the means test is designed to ensure fairness, it also is not always black and white. There are nuances, and we're to help you navigate them.
That's great. So I think in closing, what advice would you give to someone considering Chapter 7 bankruptcy? And what are some common mistakes they should avoid during the filing process?
Filing for Chapter 7 bankruptcy is a big decision, and it's important to approach it with the right information and careful planning. If you're considering Chapter 7, my advice is to take the time to fully understand your financial situation and consult with a bankruptcy attorney early on. This can help ensure that you make the right choices for your future and avoid common mistakes that could cause delays or complications in the process. Here are a few pieces of advice and common mistakes to be aware of. 1, get professional guidance. Bankruptcy law is complex, and there are a lot of nuances to the process. It's always best to consult with a bankruptcy attorney who can help you evaluate your options, determine if Chapter 7 is the right choice, and guide you through the entire filing process. Going it alone can be risky because small mistakes can lead to costly delays or the dismissal of your case. 2, don't hide assets or fail to disclose everything. One of the biggest mistakes people make when filing for bankruptcy is failing to disclose all their assets. It may seem tempting to hide certain assets to protect them, but bankruptcy courts are very thorough, and the consequences of not fully disclosing everything can be severe. If you're caught hiding assets or providing false information, your case could be dismissed and you could face legal penalties. Always be honest and transparent in your filing bankruptcy. 3, avoid taking on new debt before filing. If you're considering bankruptcy, you might be tempted to take out loans or use credit cards to cover expenses, but this can cause problems. The bankruptcy court may view this as a fraud. If you rack up bankruptcy or you rack up debt just before filing, especially if it's for luxuries or items that you don't need, keep in mind that the court will review your financial behavior leading up to your filing, and any suspicious activity could complicate the process. 4, don't transfer property or assets to others. Transferring property like a car or a home to a relative or friend to keep it out of the bankruptcy process is another mistake to avoid. These types of transfers are often seen as fraudulent and can lead to your bankruptcy case being dismissed or certain assets being seized. It's essential to be transparent about what you own and avoid trying to hide assets in advance of filing. 5, ensure that you meet eligibility requirements. If your income is above the state's median, you may not qualify for Chapter 7 under the means test, and you could be steered toward Chapter 13 instead. It's important to be realistic about your financial situation and to understand which bankruptcy chapter is best fit for your needs. Your attorney can help you navigate this and determine the best path forward. 6, don't forget about post-bankruptcy filing, post-bankruptcy planning. While Chapter 7 can give you a fresh start, it's just the beginning of your financial recovery. After the bankruptcy process is over, it's crucial to focus on rebuilding. Again, it's crucial to focus on rebuilding your credit, managing your finances carefully going forward. Many people fail to plan for life after bankruptcy, which can lead to financial struggles. We don't want to have the future financial struggles. Your attorney can help you understand the steps to take once your bankruptcy is discharged, like working on a budget, paying bills on time, and monitoring your credit. Chapter 7 bankruptcy can provide tremendous relief if handled correctly, but it's important to approach it with a clear understanding of the process. By working with a knowledgeable attorney and avoiding these common mistakes, you'll be in a much better position to get the fresh start you need without unnecessary complications.
Wow, that was so much fantastic information. Thank you for joining us today, Andrew. It's always a pleasure to speak with you.
And as usual, it's a pleasure being here and being able to explain the process of bankruptcy.
And thank you for joining us for Is Chapter 7 Bankruptcy Right for You? Understanding Who's the Ideal Candidate.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.